My name is Kate Morrison, and I want to start with the school register, because a school register is the most ordinary document in the world, and it turned out to be the most important document in my son's life. Not a birth certificate, not a DNA test, not a sworn affidavit or a legal filing or any of the documents that people associate with the kind of story I'm about to tell you. A school register, the kind that sits in a filing cabinet in a primary school office and records the names of children and their parents and their emergency contacts and their medical needs and all the small administrative details that make up the documented life of a 7-year-old boy who has no idea that his name and his father's name sitting together on a single line of a school form is about to change everything. My son is called Thomas. He is 9 years old now. He has his father's dark hair and my stubbornness, and a way of asking questions that adults find simultaneously charming and exhausting, because he does not stop until he has an answer that fully satisfies him, and partial answers do not satisfy him at all. He is obsessed with trains, not in the casual way that some children are interested in trains, but in the specific and total way that requires him to know the name of every locomotive on the East Midlands Railway network, and the precise difference between a Class 170 and a Class 222, and why that difference matters. He has been this way since he was 3. I do not fully understand it. I love it completely. His father is a man named Daniel Reeves. Daniel and I were together for 4 years and separated when Thomas was 18 months old. The separation was not clean. Separations with a child involved rarely are, and ours was complicated by the fact that Daniel's family, specifically his mother Patricia and his older sister Carol, had never considered me a suitable partner for Daniel, and had spent 4 years making that view felt in the particular quiet, persistent way that families make views felt when they are too refined to say them directly, but too committed to them to leave them unsaid. When Daniel and I separated, Patricia and Carol saw an opportunity. I did not understand the full shape of that opportunity until the morning I sat in my solicitor's office and read the statement they had helped Daniel prepare for the family court. A statement that contained, buried in its 4th paragraph, a claim that made me put the document down and look at my solicitor and ask her to read that paragraph aloud, because I needed to hear it spoken by another person to be certain I had understood it correctly. The statement claimed that Daniel Reeves was not Thomas's biological father, that I had been involved with another man during our relationship, that Thomas's paternity was in question, that Daniel, having had time to reflect following the separation, had serious doubts about his biological connection to the child, and wished the court to consider this in any determination regarding parental responsibility and contact arrangements. I looked at my solicitor. She looked at me. I said, "He has been Thomas's father since the day Thomas was born. He was in the delivery room. He registered the birth. His name is on the birth certificate. He has been at every parents' evening and every school sports day and every birthday and every Christmas morning for 7 years. And now he is telling a court he does not know if Thomas is his." My solicitor said, "I know. And we are going to prove it, starting with the documents they apparently forgot existed." I did not know yet which documents she meant. I found out the following morning, and the first one was a school register. My solicitor's name was Rachel Webb, and she had been handling family law cases in Nottingham for 18 years, and she had the particular quality of someone who has seen enough attempts to manipulate legal proceedings that she recognized the shape of them quickly and responded not with outrage, but with the focused practical energy of someone who knows exactly which drawer the tools are in. She called me the morning after I read Daniel's statement and she said, "I need you to gather every document that places Daniel Reeves in Thomas's life as his father. Every single one. School records, medical records, photographs with dates, birthday cards he signed, any written communication in which he refers to Thomas as his son, Everything you have and everything you can request from institutions that hold it. I asked her why. She said, because Daniel's statement is making a claim about paternity that is contradicted by 7 years of documented behavior. A man who genuinely doubted whether a child was his biological son would not spend 7 years attending parents' evenings and sports days and birthday parties, and behaving in every observable way as that child's father. The documents are going to tell a story that his statement cannot survive contact with. I spent that week gathering. I went through 7 years of paperwork with the methodical thoroughness of someone who has been told that every piece matters and has decided to treat it that way. Birthday cards from Daniel to Thomas, 12 of them, each one signed "Love, Dad." Christmas cards the same. A letter Daniel had written to Thomas's nursery when Thomas was 2, requesting that he be added to the approved collection list as Thomas's father. The school secretary, a woman named Mrs. Barlow, who had worked there for 22 years and who knew Thomas by name and knew his train obsession, and had once spent 15 minutes listening to him explain the difference between a diesel multiple unit and an electric multiple unit with the patience of a saint, said she would pull the file and have copies ready by Thursday afternoon. I collected them on Thursday. I sat in my car in the school car park, and I opened the envelope, and I read through the documents one by one. Thomas's enrollment form from reception year. Parent 1, Kate Morrison. Parent 2, Daniel Reeves. Relationship to child, father. Emergency contact, Daniel Reeves, mobile number provided. Medical information form, signed by Daniel Reeves as parent. The annual review form from year 1 with Daniel's signature at the bottom, confirming he had attended the parents' evening and discussed Thomas's progress. The same form from year 2 with the same signature. The sports day permission slip from last summer, signed by Daniel as Thomas's father, authorizing Thomas to participate. 7 years of a man being a father. Documented, dated, signed in his own hand. I sat in the car park and I thought about the 4th paragraph of Daniel's statement. The careful language of it. The claim constructed with the particular legal precision of people who had thought about it carefully before committing it to paper. I thought about Patricia and Carol and the 4 years of quiet, persistent views about my suitability, and what it meant that those views had eventually produced a statement denying that Daniel was Thomas's father. Then I put the documents back in the envelope. I drove to Rachel's office, and I put 7 years of evidence on her desk. Rachel looked at the documents for a long time. Not quickly the way people look at things they are processing for immediate use. Slowly, and in order, the way someone looks at things they are building an argument from, and want to understand completely before they begin to build. She laid them out on her desk in chronological order, the enrollment form from reception at one end, and the sports day permission slip from last summer at the other. And she looked at the line they made across her desk. 7 years of Daniel Reeves being Thomas's father in every documented way available to him. And she was quiet for a moment. Then she said, "He signed all of these himself." "Yes," I said. She said, "His signature is consistent across 7 years. This is not someone else signing on his behalf, or a form filled in by default. These are active choices. A man who attends a parents' evening and signs the review form is a man who went to the school, sat in the chair, talked to the teacher, and put his name on the document. That is not passive participation. That is deliberate and repeated engagement with the role of father over 7 years." "I know," I said. She looked at the birth certificate. She said, "He registered the birth himself. His name on a birth certificate is not automatic. He had to go to the register office. He had to present himself. He had to provide his details and sign the register. In English law, a man who registers a birth as the father has parental responsibility from that moment. He did that when Thomas was 12 days old." "I know," I said again. She looked at me. She said, "Kate, I want to be honest with you about what I think is happening here. The paternity claim in Daniel's statement is not genuine. A man who genuinely doubted whether a child was his would not have spent 7 years doing everything Daniel has documented himself doing. This claim has been introduced into these proceedings for a specific purpose, and that purpose is not to establish the truth about Thomas's paternity. It is to create uncertainty, to introduce a question that shifts the court's focus from Daniel's behavior as a father to a biological question that feels more fundamental and that, if left unanswered, gives the court a reason to pause on contact and parental responsibility arrangements while the question is resolved." I looked at the documents on her desk. "That is what Patricia and Carol advised him to do," I said. "I am certain of it." Rachel said, "I cannot speak to that. What I can speak to is the legal response. We submit all of these documents with a formal response to the paternity claim. We request that the court note the 7 years of documented paternal involvement that directly contradicts the claim. And we request a DNA test, not because we need it to prove what we already know, but because a DNA test resolves the question permanently and removes the uncertainty that the claim was designed to create." I asked her how long a DNA test took. She said, 2 weeks for results. "But Kate, I want you to understand something. The DNA test is not our strongest argument. It is our cleanest argument. Our strongest argument is sitting on this desk right now. 7 years of a man choosing to be a father in every documented way available to him, in his own handwriting, on forms he attended in person to sign. A DNA test confirms biology. These documents confirm something that matters more in a family court than biology." I looked at the line of documents across her desk. "What does it confirm?" I said. She looked at me. "It confirms," she said, "that whatever Daniel's statement claims about paternity, Daniel Reeves has spent 7 years telling every institution responsible for Thomas's welfare exactly who he was to that boy. And you cannot spend 7 years telling the world something, and then tell a court the opposite and expect the world not to notice." I thought about Mrs. Barlow in the school office pulling Thomas's file, 22 years at St. Andrew's Primary, and a patience for train facts that I would never stop being grateful for. I thought about the enrollment form. Parent 2, Daniel Reeves. Relationship to child, father. His handwriting. His choice. 7 years ago. The DNA test was ordered by the court on a Tuesday in March. Not because Rachel had requested it alone, because Daniel's solicitor had also requested it, which told me something important about the strategy behind the paternity claim. They wanted the test. They had introduced the uncertainty specifically, so that the test would be ordered, and the proceedings would pause around the question of biology, while the contact arrangements remained unresolved, and Thomas remained at a distance from the consistent paternal presence he had known for 7 years. The test was not the conclusion of their plan. It was the mechanism of delay built into it. Rachel had anticipated this. She had submitted all 7 years of documents with our formal response before the test was ordered, and she had done it specifically. I took Thomas for the DNA swab on a Wednesday morning. I had told him it was a health check, the same gentle misdirection I had used once before with a different test in a different context, and he had accepted it with the pragmatic cooperation of a child who trusts that adults have reasons for the things they ask, even when those reasons are not fully explained. He sat in the clinic chair and opened his mouth, and held very still, and then asked the nurse whether she knew the top speed of a Class 800 Azuma train, which she did not, and he told her it was 125 miles per hour. And she said that was very fast, and he said, yes, it was one of the fastest in the network, and she said she would remember that. And I sat beside him, and I looked at his dark hair and his serious eyes, and I thought about Daniel registering his birth when he was 12 days old, and I thought about the enrollment form and Mrs. Barlow and the patience of saints And I thought about Patricia and Carol, and the 4 years of quiet, persistent views that had eventually produced a paternity claim in a family court document. I thought about what the result was going to show. I was not anxious about the result. I want to be clear about that. I knew what the result was going to show because I knew the truth of Thomas's conception, and I had always known it, and no amount of carefully constructed legal language could change a biological fact. What I was not certain about was what Daniel knew, whether he genuinely believed the claim his statement made, or whether he had been told to make it by people who had decided that winning the legal proceedings mattered more than the truth of a 7-year-old boy's parentage. The result came 2 weeks later. Daniel Reeves was Thomas's biological father. Probability of paternity, 99.9%. Rachel submitted it to the court the same day it arrived with a covering letter that was 4 sentences long, and that said everything that needed to be said without wasting a word. The paternity question has been resolved. The DNA analysis confirms that the respondent is the biological father of the child with a probability of 99.9%. The court's attention is respectfully directed to the 7 years of documented paternal involvement previously submitted, which must now be considered in conjunction with this biological confirmation. The applicant requests that the court proceed to determine contact and parental responsibility arrangements without further delay. 4 sentences. 7 years. 99.9%. I sat at my kitchen table that evening, and I read those 3 things together. And I thought about the 4th paragraph of Daniel's statement and the careful legal language of people who had decided that uncertainty was a useful tool and had introduced it deliberately into proceedings involving a 7-year-old boy who collected train facts and trusted adults to have reasons for the things they asked. They had miscalculated. The uncertainty had lasted exactly 2 weeks. The hearing was on a Thursday in April, and I want to tell you about the moment Patricia and Carol walked into that courtroom because that moment told me everything I needed to know about how certain they had been that their plan would work. They were dressed carefully, not formally in the way of people attending something serious and wanting to convey respect for the proceedings. Carefully in the way of people attending something they expected to win and wanting to look appropriate for a victory. Patricia had her hair done. Carol was wearing a jacket I had not seen before. They sat in the public gallery behind Daniel's table, and they did not look at me when I came in, and I understood from the nod, looking that they had spent the week since the paternity claim was filed constructing a version of events in which my presence in that room was temporary. They had not seen the DNA result yet. Daniel's solicitor had received it. Daniel had received it. But Patricia and Carol were not parties to the proceedings, and the result had not been shared with them by the time they dressed carefully and drove to the courthouse on a Thursday morning, expecting to watch the conclusion of a plan they had helped construct. I sat beside Rachel, and I did not look at them either. The judge was a man named His Honor Judge Stephen Carroll, and he had the efficient, no-nonsense quality of someone who had been on the family bench for 20 years and had learned to identify the shape of proceedings quickly and respond to what he saw rather than what he was told. He had read the documents. All of them. I could tell this from the first 5 minutes of the hearing from the specific and pointed questions he asked Daniel's solicitor before the formal submissions had even begun. He said, "Mr. Foster, I have reviewed the paternity claim submitted in your client's statement, and I have also reviewed the enrollment records, medical consent forms, parents' evening attendance records, and birth registration submitted by the applicant. I have a question before we proceed. Can you explain to the court how a man who registered a birth, attended 7 years of parents' evenings, signed medical consent forms, and maintained consistent contact with a child can simultaneously claim to have serious doubts about his biological connection to that child?" Richard Foster looked at his notes. He said, "Your Honor, My client had reason to believe during the period of the relationship that the applicant may have been involved with another individual, and those concerns resurfaced following the separation. Judge Carroll looked at him. He said, "Those concerns resurfaced following the separation. Not during the 7 years in which your client was signing school enrollment forms as the child's father. Not during the 7 years in which your client was attending parents' evenings and signing the review forms. Following the separation." Richard Foster said, "Your Honor, my client." Judge Carroll said, "Mr. Foster, I have the DNA result. Your client is the biological father of this child with a probability of 99.9%. The paternity question is resolved. What is not resolved, and what I intend to address directly this morning, is the question of why a claim that is contradicted by 7 years of documented behavior and 2 weeks of biology was introduced into these proceedings in the first place." The room was very quiet. I did not look at Patricia and Carol in the gallery behind me. I did not need to. I could feel the moment the carefully dressed certainty of a Thursday morning expectation became something else entirely. I looked at Judge Carroll. He was looking at Daniel, and Daniel was looking at the desk in front of him with the particular stillness of a man who has followed a plan to its conclusion, and is only now, in a courtroom on a Thursday morning in April, understanding what the conclusion actually looks like. Judge Carroll spoke for 12 minutes. I know it was 12 minutes because Rachel told me afterward that she had been counting without meaning to, the way you count things when you are sitting very still and need something to do with the part of your mind that is not listening. He spoke in the measured, careful language of a judge who has arrived at conclusions he wants the record to reflect completely, and who is not going to hurry through them simply because the room is uncomfortable. He confirmed the DNA result and noted that the paternity question was resolved entirely in favor of Daniel Reeves being Thomas's biological father. He noted that this result was entirely consistent with 7 years of documented behavior that had never wavered in its characterization of Daniel as Thomas's father. He noted that the paternity claim introduced into the proceedings had been unsupported by any evidence beyond assertion, and had been directly contradicted by both the documentary record and the biological evidence. He described the introduction of the claim as deeply concerning, and noted that the court took a serious view of applications that introduced unfounded questions about a child's parentage into family proceedings given the potential harm to the child's sense of identity and security. Then he addressed the contact and parental responsibility arrangements. He granted me primary residence. He granted Daniel structured contact every other weekend and 1 evening midweek, subject to a review in 6 months. He noted that the 7 years of documented paternal involvement were evidence of Daniel's capacity to be a positive presence in Thomas's life, and that the contact arrangement was designed to preserve that capacity while ensuring Thomas's stability and continuity. He did not grant Patricia or Carol any formal role in the proceedings or the arrangements. He awarded costs against Daniel, and in his written judgment, which Rachel received 3 weeks later and read to me on a Tuesday evening over the phone, he included a paragraph that I have read many times since and that I want to read to you now, because it is the most important thing anyone said during 14 months of proceedings. And it was said by a judge who had looked at a school register and understood what it meant. He wrote, "The court notes that the most compelling evidence in these proceedings was not the DNA analysis, though that analysis was determinative on the question of paternity. The most compelling evidence was the 7-year documentary record of a man choosing, repeatedly and in his own hand, to identify himself as this child's father to every institution responsible for the child's welfare. That record was assembled not in anticipation of legal proceedings, but in the ordinary course of a father's life. It cannot be constructed retrospectively. It cannot be denied. And it speaks more clearly to the truth of this child's family than any statement prepared for the purpose of litigation." I put the phone down after Rachel finished reading, And I sat at the kitchen table in the quiet flat and I thought about Mrs. Barlow at St. Andrew's Primary pulling Thomas's file. With the patience of a woman who had spent 22 years watching children grow up and understood without being told that the file she was copying mattered. I thought about the enrollment form. Parent 2. Daniel Reeves. Relationship to child, father. His handwriting. His choice. 7 years ago. I thought about Thomas in the next room building a train layout on the living room floor with the focused ambition of someone who has decided the East Midlands Railway network deserves accurate representation and is going to achieve it regardless of how long it takes. Patricia and Carol had driven to that courthouse on a Thursday morning in carefully chosen clothes, expecting to watch a plan reach its conclusion. The plan had reached its conclusion. It just was not the conclusion they had dressed for. Thomas called me from the living room. He said, "Mum, do you know the difference between a class 156 and a class 158? I said, "Tell me." He told me. I listened to every word. Some things are exactly as they should be. Some things were always going to be exactly as they should be. And nobody, regardless of what they file in a family court on a Thursday morning, can change what 7 years of ordinary mornings have already made true.